Everyone, we're starting live. This is Kim Wehle in the Little Law School, and I'm so delighted to have this conversation today with my colleague, Gilda Daniels. Welcome, Gilda.
Good morning, Kim. How are you?
I'm well. I'm well, even on this precarious moment for American
Yeah,
democracy today, this week, right?
that's what it is.
Gilda, you and I met, I think, in a brand new law professor training conference so many years ago, and we wound up in the same law school, and now I think two doors down on the same floor, dealing with the same some of the same issues facing
Absolutely.
our Constitution and our democracy.
I was only going to say, don't give the number of
Okay.
years.
Okay. Well, it's really just, it's great to be with you, even if it's not in the best of circumstances. I
Yeah.
invited you today, and I see we've got lots of folks joining. Thank you so much for being with us in the Little Law School. Um, Gilda, maybe you can give a bit about your background because it's
Okay.
so impressive on voting rights and election law, which is, again, why we're talking today, because I want to break down Louisiana versus Calais, the
Yeah.
decision this week by the conservative or really far right majority that basically cuts down, almost obliterates Section 2 of the Voting Rights Act. Can you tell us why are you a good person to talk about this with?
Good morning again, Kim. So, in regards to my background, I am, and I think it's a very interesting fact. I'm from Louisiana, so it's and a graduate of HBCU, Grambling State University, and went from Grambling to New York University Law School. Clerked in the 11th Circuit, so I'm familiar with Florida, so that always comes up. And clerked in the 11th Circuit, and then worked in Alabama and Georgia with the Southern Center for Human Rights, representing death row inmates and bringing prison condition cases. After that, I went to the Department of Justice in the Civil Rights Division voting section. In 2000, I was a deputy chief, became a deputy chief in the Civil Rights Division voting section at the Department of Justice. I was in the room when it happened, when Bush v. Gore happened, when we realized we didn't have any attorneys or personnel in the state of Florida in 2000, and that we quickly had to adjust. So I've been at the law school. So I've moved from certainly with the Department of Justice Civil Rights Division voting section, where we certainly defended. It was a different voting section and a different Department of Justice back then. But that could be a whole nother podcast in regards to certainly the work that we did at the Department of Justice to enforce the Voting Rights Act and other federal voting rights and other federal legislation in regards to voting rights, and have been in the voting rights area for almost 3 decades.
Right,
I'm
and you've got this great book that's behind you called Uncounted. Um, I, I was just on a different show on XM Radio, and
Mhm.
the host asked me a question about a poll that XM had just done of their viewers or listeners, and should race be considered in gerrymandering? And a majority of the respondents said no, race should not be considered in gerrymandering. What's gerrymandering or redistricting? It's when every 10 years after the United States Census, the state legislators decide how to carve up the state for purposes of the representatives in the House of Representatives. And you'd think, okay, if you've got four, make a perfect square, and you have four squares. No, gerrymandering is you pick your voters, you carve it up in a way so that you get voters that are going to entrench your power, or you split groups of people that would otherwise maybe not be consistent with your ideology or your political party. So that's what gerrymandering is. Um, and I want to ask, so this question of, is it bad to consider race? And that people think, oh, it's just bad to consider race. You said you're from Louisiana. This case was about Louisiana. Another case arose in Louisiana. It was called Plessy versus Ferguson.
Yeah.
And that was the Supreme Court case in which a majority said that segregation was constitutional. It was about a white only car, and a person of some African American descent, Homer Plessy, sat in the wrong car in violation of Louisiana law. Can you tell us,
Mm.
what is the thread between Plessy versus Ferguson, which is, I think everyone agrees, a stain on our nation's history. It was an abomination as a matter of the Constitution. And what happened today, or excuse me, this week?
Well, I think it's in even uh, before we get to Plessy versus Ferguson, we we're at I think we have to also talk about the history of the use of race in this country. And talking about enslavement and the fact that we had a civil war, right? We had a civil war, and then we had the 13th, 14th, and 15th Amendments, which and we had the Emancipation Proclamation. So I think so. So this idea that we should not consider race under any circumstances, that we want to be a colorblind society, is certainly, I think there's a misunderstanding, because racism is structural, systemic, and embedded in ordinary, certainly institutional practices. And so this idea of certainly having being colorblind, or even under looking at the equal protection doctrine, certainly assumes that racism is exceptional, intentional, and aberrational, and with treating racism as something done by bad actors at discrete moments, certainly with some identifiable intent. And so this idea that we shouldn't use race, because of how our country has systemically used race to determine certainly who gets what opportunities, who gets access to power, who gets what neighborhoods you live in, the type of education you receive. This country has, and because we've made certainly racism ordinary, it's a part of our society. There's certainly the use we're used. So this, for folks who say we shouldn't use race, or don't are certainly not understanding that we use race all the time, and that we use race all the time to make determinations about what laws, what policies, what practices, certainly, and what decisions are being made. So, in regards to, so I think it is important to go back through history, because this court that talks about history and tradition in the Dobbs case, but for some reason can't get their history straight in regards to the passage of the Reconstruction Amendments. The purpose of the Reconstruction Amendments was certainly to ensure that persons of other races, other than white, could have the same and certainly equal access, and equal opportunities. And so with the adoption of the 13th, 14th, and 15th Amendments, and certainly the Emancipation Proclamation, with the end of slavery, and with the 13th, 14th, and 15th Amendments, they are race conscious amendments. They are race conscious. And so this idea that we should cover our eyes and not consider race is not something that the Constitution does.
So
Uh,
it's not a colorblind
it's
constitution,
not a
in
colorblind.
that I mean, the one analogy I like to use is as if we just had Olympics games, right? So everybody starts at the starting line, and the fastest runner wins. Well, what the 13th, 14th, and 15th Amendments and the Voting Rights Act, which was enacted as Congress was constitutionally authorized to implement the 15th Amendment, because Southern states were outmaneuvering all of these adjustments, is to basically say we're recognizing, after hundreds of years of enslaving people based on their race, degrading people, treating them as subhuman, that we need to try to lessen that the delta between where white people are starting and where everyone else. The no so yes, race is the reason that people are starting miles behind in the very same race, so to speak. And that's what the idea is behind the Voting Rights Act as well in 1965, looking at all of those years, 95 years since the post Reconstruction amendments, where people of color still were not able to vote. There were poll taxes, there were all kinds of stuff happening. There was violence at the polls. There were all kinds of things. They weren't able to vote, and so the Voting Rights Act was designed to fix that problem.
But but before we get to the Voting Rights Act, let's stay with the Reconstruction Amendments. And so after the adoption of the 13th, 14th, and 15th Amendments, the 13th Amendment freed slavery, said there should no longer be slavery. 14th Amendment provided equal protection under the laws and also included birthright citizenship. And the 15th Amendment gave the right to vote to Black men, right? And when Black men certainly engaged and decided that they would utilize that right to vote. They considered certainly the right to vote a right of citizenship, right? And so you get the right to vote, and they elected persons to the United States Senate. In 1871, you had like 4 or 5 African American Black men in the United States Senate. The state of Mississippi elected 2 Black men to the United States Senate in a very short period of time, in a 10-year period. And it would take us until 2020 to have 2 Black men from the South in the United States Senate again. So you have this more than 150-year span of when you're looking at certainly the role that certainly the 13th, 14th, and 15th Amendments played in access to the right to vote, and in having the ability to register and vote Blacks elected persons to state, local, and federal offices. You can thank the 15th Amendment, and you can thank Black men during Reconstruction for Board of Elections, right? Because there are 2 things that were very important: the right to vote and education. So you have the 13th, 14th, 15th Amendments, and they've elected more than 2,000 persons to various levels of governance. And you then have the Hayes-Tilden Compromise that said that in order for the Confederate states to return to the Union, they had to adopt the 13th, 14th, and 15th Amendments. And the Confederate states said, okay, sure, we'll do that. But in doing that, we will also pass these laws that will make it harder for Black men to register and to vote. So in places like Alabama, where they had more than 100,000 Black men who were registered to vote, certainly during that Reconstruction period, that short period of 10 to 15 years, after they had held their state constitutional conventions in the early 1900s, where they passed poll taxes, literacy tests, felon disenfranchisement laws, and where they selected the kinds of crimes that they believed Black men committed more often than white men. In Mississippi, those were they said that they believed that Black men committed wife beating and timber theft more often than white men. So those were disenfranchising crimes, but rape and murder were not. Right. So it's just an example of how during that period you had state legislatures crafting laws that were meant to disenfranchise Black men, and they did so effectively in states like Alabama. Those numbers went from 150,000 to 46. In Louisiana, that number went from 100,000 to 1,000. And so it's just an example of how the development of these laws, and so this idea that we should be colorblind and pass these laws that appear neutral, but certainly those laws had the result of ensuring that Black men would no longer have the right to vote.
And that's basically what Justice Alito, in his majority opinion, is saying, right? That okay, if you are going to challenge a map, you can't challenge it based on the impact on African Americans. That is a third being Black, but only one of the 6 districts being minority dominated. You have to show that the legislators, the people in the state legislature, intentionally and purposefully were being racist. Which Justice Kagan in her dissent says, that's basically gutting the Voting Rights Act, because it's, no legislator is going to be dumb enough to put that in the record, right? So you can pretend that this is a race neutral map, wink, wink, nod, nod, um, and get away with turning the clock back to maps that favor people who historically have had, more power, which is white people. Is that a fair assessment of what's happening with this case?
It's worse than that. It's worse than that because have we had to wait 100 years after the Reconstruction Amendments to get the Voting Rights Act, and it's completely ignores certainly the history of why we needed the Voting Rights Act and why Congress thought it was important to have not only not why Congress thought it was important to not only have the Voting Rights Act but to reauthorize it several times. And so, with the need for the Voting Rights Act, as you mentioned, certainly there were the barriers to the voting booth were not only legislative, with poll taxes, grandfather clauses, literacy tests, but they were also there was also violence. Jamaica Evans was killed in his driveway for registering people to vote in the state of Mississippi. And there were countless massacres for people around Black people trying to exercise their right to vote, and the whole civil rights movement, right? And so there's a history around why we needed the Voting Rights Act, because in places like Mississippi in March of 1965, less than 10% of Black persons were registered to vote, as compared to more than 60% of white persons.
So are you suggesting, Gilda, we could go back to that? We could go back to violence at the polls? Is that when you say it's worse than that, or are you
Well,
saying that?
I'm saying it's worse than that because the reason for the Voting Rights Act and this idea that Alito's being completely disingenuous and in his assessment of the Voting Rights Act, and because the Voting Rights Act is premised upon certainly the powers, the authority given to Congress in the 14th, 15th Amendments, because they completely ignore the record. They completely ignore the reasons. If he's an originalist, certainly what did the drafters at the time of the 1982 reauthorization of the Voting Rights Act intend?
Well, let me
Right.
give you another rationale that we saw in the Harvard affirmative action case, right? And just so people are clear, I think there's a mythology around affirmative action that there are set-asides. I mean, set-asides for people of color were declared
Yeah.
unconstitutional, decades ago. This was just, can you consider race among a multitude of factors? And the argument that seemed to carry the day in part in the majority was, well, it's time to move on, that we've gone far enough. This is why the Supreme Court justified in a case called Shelby County getting rid of another part, essentially, of the Voting Rights Act, which required the Justice Department or federal courts to check to see if new voting laws were being unfairly negative on people of color. They got away with that. Justice Alito, in this opinion this week, says, listen, it's time to move on. It's time to move on, Gilda. I mean, my response to that is, listen, maybe it's time to move on, but it should be the U.S. Congress that makes that decision, not unelected justices on the Supreme Court. But can you respond to that more head on? I don't have your expertise in what it's like on the ground when it comes to discrimination in voting.
Well, I think when racism has an expiration, when we stop racism, that's when we no longer need the Voting Rights Act. These kinds of measures are needed to certainly address the discrimination in education, discrimination in employment, discrimination certainly in the right to vote. And certainly, the interesting thing about the Calais case was that there was a decision that was made by 6 different judges that the map that the state of Louisiana drafted that included only one majority minority district was racially discriminatory under the Voting Rights Act. That this was the drawing the 1 out of 6 districts as a majority minority district in a state where 30% of the population was African American. Was the courts found that the plan was racially discriminatory, and then instructed them they had to then draw a new map with two majority minority districts.
Well,
And they get the 2 out of 6. And so they did that. And so just saying, and so and so those that are not guarantees that blacks will be elected. They are opportunities. The Voting Rights Act said that you have to have an equal opportunity to elect. And just as with affirmative action, it provides opportunity. There are no guarantees but the reason for affirmative action laws, as well as certainly the Voting Rights Act, was to ensure that persons of color would not be discriminated against. And so this whole ignoring the fact that discrimination exists, and certainly and not existed but exists, certainly in who gets selected for what seats and who and how districts are drawn, is something that this legislation contemplated and addressed.
yeah, the premise seems to be that addressing racism is racist. And therefore, the Voting Rights Act, which is designed to address systemic racism, is racist and therefore unconstitutional. I mean, this is like such like a shell game, you know, turning the history of the post Reconstruction, the Reconstruction Amendments on its head. And I don't think enough people are really talking about what's actually going on. I know the affirmative action case laid the groundwork for Donald Trump's purge of, quote, DEI, diversity, equity, inclusion. The idea being anything that takes into account of race is somehow unconstitutional. That is not the history of our Constitution post Civil War, and it's certainly not our history writ large of race relations in this country. But I wonder if I could push you just on one statement you made, and I say this because I think it's really important. I'm sure you agree with this. That those that don't understand this or maybe have a different political leanings, like they really can get more of a flavor of what this means from a day-to-day basis. You mentioned that, we'll sunset these provisions when racism ends, right?
Mhm.
Some people would say, okay, I just don't understand what that means in 2026 because I have a kid,
Mhm.
who had applied to college and had all of these things on their resume and didn't get into XYZ, or I know someone, or I was up for promotion and it went to a person of color. I think people experience in certain walks of life in the United States a sense that, listen, the tables have turned and it's become unfair to take into account race. And I don't think, Gilda, it's all or nothing, right? It's not all or nothing. Sometimes it gets a little bit of messy addressing it. But can you talk a little bit about what would it look like, um, in your view, to have racism end in the United States? What would that actually look like? What is the goal? And what, right? Because I think some of us would love to see that, and don't want to think it's impossible. But if we were just to dream a big dream in this moment and try to be positive, what would that look like, Gilda?
Well,
It
Kim,
certainly is not what Justice Alito envisions.
well, so I would say it's not the Calais case. Um, and so in envisioning, and if we just stick to what it looks like in regards to the right to vote, it would be persons having free and fair access to the right to vote, right? And in regards to districts, certainly, when you're drawing districts, you can consider communities of interest. Right, that's one of the contemplations. But I think it's certainly in regards to having free and fair access, I think this is an opportunity for us to reimagine what we want society to look like, what we want the redistricting to look like, what we want elections to look like, what we want our country to look like. And I think it's in regards to, and I think what we want is we don't want So what Alito did, he said that, okay, we can use partisanship, but well, we can't have, we can use partisanship to draw these districts, but we can't ever use race, right? And so you and so and then and the fact that um partisanship in regards to elections is equal to race, right? Because you're saying, oh, well, they didn't, because now all the uh, legislators have to say is that we didn't do it because they were Black. We didn't draw them out of their districts or lessen their ability to elect their candidates of choice because they were Black. We did it because they were Democrats. And the it is certainly apparent to everyone that the African Americans are overwhelmingly registered as Democrats, right? So
So for you, would it
it's a
be
it's a game of semantics. It's a way of, I mean, don't go for the okie doke. It's a way for them to racially discriminate, but call it something else, and calling it partisanship. And so I think what needs to happen if we want to see this equality is we have to get rid of partisan gerrymandering. We just have to get rid of the way that we redistrict, and we've been saying this for a while. Certainly, I mean, and I think there are certainly things that we have to do to ensure that and there are other ways that we can elect persons to um, Congress and other bodies without districts, which may be and also another alternative. So there are other alternatives and ways that we can see certainly free and fair elections, but we have to get rid of partisan gerrymandering. And it's important for people to understand we still have the right to vote, and we still have elections, and we have um, regime change in this country through elections. And I think it's important for people to certainly understand what they need to register, uh, and as well as what they need to actually cast the ballot, and make sure that we do that come moving forward in November. I know I'm running ahead, but I think it's important to
yeah.
point it out.
So when you say we need to end partisan gerrymandering, just to be clear for folks, it means that when these districts are carved up, that is, which representative represents which territory in which state, it cannot be carved up based on Republican versus Democratic voters, because that's essentially a proxy for race.
Yeah.
And so by saying that's okay, but race is not okay,
Right.
the majority is essentially saying go ahead and disenfranchise Black voters by calling them Democrats. So that would be one fix. And you, in our conversations before this talk, you mentioned Raphael Warnock, and there have been other members of Congress that have proposed legislation. There's also redistricting commissions, neutral redistricting commissions. Virginia has one, but Virginia voters kind of outmaneuvered them and create. Passed a constitutional amendment to allow the Virginia legislature, Democratic legislature, to gerrymander 10-1 districts. I think what we're seeing right now is now this race to the bottom of gerrymandering because it's gotten so out of control. So my question for you is, and I agree with you, vote, vote, vote. But at what point will legislators, they like power, well, they say, okay, I'm going to give up power by diluting my district. Like, we can vote, but we need to put people in office that are willing to give up the reins of power through gerrymandering. And the Supreme Court, as
Yeah.
you know, also in a case called Brnovich, basically said you can't even sue about partisan gerrymandering. I mean, they've really made this. This is like the Thanksgiving dinner. This is the turkey. This is now the driving force in our elections, is letting these politicians, these completely polarized, ideological, power-driven politicians, to dictate our elections. So what would that look like, Gilda, for the voters to be able to take that back and persuade them, no, actually, why don't you enact some things that are a little more fair for the rest of us? We the people, not we the politicians.
Ballot initiatives. So I mean, there are certainly ballot initiatives that in your state, in your jurisdictions. We've certainly saw that in places like Florida, where they decided on the same day that the Calais case was decided, that that DeSantis decided, okay, we're going to institute a partisan gerrymandered plan, which essentially they have already decided that, excuse me, incumbency and other considerations should not be used in the districting process. So the Florida plan is a violation, certainly is a violation of their state constitutional amendment. And so I think certainly this is really a stop the steal. I think our position now is certainly a stop the steal position. They are trying to steal elections, and certainly for legislatures, I think it is very important that now we're all getting a civics lesson, and we can, and that is that it is the state legislatures that draw the districts. So it's important for those persons who are in states where the state legislature is up, like in Maryland, where the state legislature is up for election, that you vote in people who also oppose partisan gerrymandering, and ensuring that as well as in states where it's allowed, start the process of initiating ballot initiatives that say you'll have a redistricting commission, that you'll have that you are opposed to partisan gerrymander. And I think it's also important to partner with organizations that are doing the work and that have been doing the work, like the Lawyers Committee for Civil Rights, like Campaign Legal Center, like the NAACP Legal Defense Fund, like the NAACP, right, and Southern Poverty Law Center and others.
So that's one of the questions we've had in the chat, which is, okay, I want to make a difference. So where you said partner with these places,
Yeah.
what can somebody watching literally do when we sign off this conversation? What's the next thing? I mean, my guess is you'd probably say, at least I would say, is make sure that you're registered to vote in November, and that means going to the Secretary of State website for your state and just double check all of that so you're not caught flat-footed, and make plans to do it. But what else? This is I think a red light moment, and it's a time for people to come together. So specifically, what can you go do? Because one thing I appreciate about you, Gilda, you always have hope in your voice. And so let's end on that.
Well, so I tell people that there's a few things you can do: educate, legislate, participate. Okay, educate yourselves about the process. Certainly, these continue to come to Kim's podcast and learn about certainly what's happening, and certainly how it can impact us on an everyday level. And so certainly educating ourselves about these laws, about these court cases that are being uh, rendered unto us, as well as what legislation is being passed and how it can affect certainly your ability to vote, your ability to get an education, your access to healthcare and other measures. And when I say so, educating yourselves certainly about the process of voting. Make sure that you're registered, as well as understanding certainly what identification is necessary in your jurisdiction, because there are various voter ID laws across the country. So educating yourselves, and then legislating, certainly looking to see what laws. There are places like VoteBeat. VoteBeat is a good um, website for just learning what laws in regards to certainly the right to vote and how they may impact you. NPR is always a good source as well. Brennan Center for Justice and other places. Just certainly looking at legislation, and participating. And that includes joining organizations like the ACLU, like the NAACP, like the League of Women Voters. And there are local organizations like Black Voters Matter, which certainly has more of a regional effect. And there are organizations that have been working on these issues, some for decades, and certainly organizations like the NAACP for more than a century. So there are organizations in place that are working on these issues and that will continue to on these issues. And I also want people to consider running for office. I think if you're not pleased with your representation, then you should consider becoming a candidate for your local school board, because it's not just the federal elections; it's local school boards, city councils, county councils, as well as the state as well as the state legislature. So it's important to certainly there are organizations that are doing this work that are certainly in the litigation space, certainly supporting organizations like Campaign Legal Center, NAACP, LDF, uh, Lawyers Committee for Civil Rights under law, and I'm certainly missing some other Advancement Project and others that are doing the work in the courts to ensure Brenner Center for Justice to ensure that we continue to have unfettered access to the right to vote. It is a battle, Kim, and I think it's
Yeah, I know.
important for people to understand that, and that it is cyclical. We had some great progress, and now we're on the downside in regress. But I can have hope because, as I say in my book, Uncounted, I use the framework of my 99-year-old grandmother and all that she saw over her years. And now recognizing, I can have hope because I recognize we have more resources now than we did uh, when she uh, uh, when she was growing up, and certainly living through the 1950s, 60s, 70s, 80s, 90s. We have more resources. We have more education, and we have more power. And so we have to certainly use that power.
Yeah,
Uh,
and more partnership. I mean, I hope people can. One of the things I try to convey across all of these topics is that this affects everyone. I mean, this is not just not to use just, but this isn't just about racial justice and African American voters. This is about a democracy itself and whether we are in charge of our government or those in power are in charge of our government. And that is slipping through our fingers on so many levels. And this is just the latest but very, very serious, egregious direct step in that direction. Gilda, I know you also do a podcast or interviews on LinkedIn, so everyone please check that out. Gilda Daniels, also, as you mentioned, your book Uncounted, which is one of the premier stories of voter suppression in America. So educate, educate. I'm 100% behind that, and it's really a pleasure and an honor to talk to you. Thank you. It's been great to be your colleague, and I'm glad you're in the fight, Gilda.
Fight on, honey. It's a fight to vote for the right to vote.
Love it.
Thank you, Kim. It
Okay.
was my pleasure.
Thanks to everybody who joined. This is The Little Law School with Kim Wehle. We'll see you next time. Bye.
Okay.